Hello and welcome back. We're moving on now, still staying with companies, but we're starting to look at how companies are owned and how they are managed. And this chapter is still quite important, probably worth about 5 marks in your exam, 5 questions, but not quite as important as the previous chapter. Now we're going to divide this into sections, and in this first lecture we're going to look at the role of the company director. Then we'll come back and look at the role of the director's duties and powers, and finally we'll look at shareholders and their duties. So first of all, let's look at directors. So a director is the person who has the role of managing or running the company. Now, your initial directors are named in the company's incorporation documents. Remember, there is that statement of officers that you file with the company registrar. Subsequent to that, directors can be appointed by following the procedure in the articles. Now, that is usually that they are either co-opted by the existing directors, in which case it's usually the articles provide for that director to be confirmed in the next general meeting by the shareholders. Alternatively, a director can be appointed by the shareholders, and that is basically by an ordinary resolution. Remember, an ordinary resolution is greater than 50% of the votes. So the majority of the shareholders who voted for you. But there are a number of other types of company directors. Now, the Companies Act applies equally to all these classes of directors. You don't have to be officially appointed in order to fall within the provisions of the Act. It's enough that you are acting as a director. So we have a de facto director, which means literally a director in fact. This is someone who hasn't been formally appointed but acts as a director. Everybody thinks he's a director, he behaves like a director, and in that case, for the company's law purposes, he probably is a director. We also have a shadow director, and again, this is a person who hasn't been formally appointed, but someone within whose directions and instructions the directors are accustomed to act. So somebody who literally dictates what the other directors do. Now, I always think of this as an illustration, the sort of matriarch of the family perhaps, that isn't actually officially involved in the running of a company, but every night tells the boys what they need to do, and every day they go away and they implement her instructions. In that case, she would be a shadow director. Now, the key difference there between a de facto director and a shadow director is that you know you're dealing with a de facto director. You may not know they're not officially appointed, but you know who they are. They're acting as a director. But the shadow director, they're sitting there in the shadows, in the dark, and you may never, ever meet them. The last one there, less common, I've never seen this one in the exams yet, but this is a proxy director, or an alternate director. So perhaps you are going to be in hospital for a period of time, perhaps you're going to be away for a period of time, and you appoint somebody to act as a director during your absence. And then some further terms. This is more about the job that the director does. An executive director has a specific role in the business. The sales director, the managing director, the finance director. And it's usual that these people, although they are an officer of the company, they are also an employee of the company, and their job is to run the day-to-day business. A non-executive director, this is something that is very important in our corporate governance. Because our non-executive director, he doesn't have a specific role in the company. He doesn't have a particular job to do. His job really is to attend the board meetings. And he comes to the board meetings and he challenges the decisions that have been made by the executive directors. And his job really is to try and ensure that the company is properly run. Now, a board of directors normally has a chairman, and the chairman's job is to run the board of directors, and he is usually also a non-executive director. Alongside him, we might have the managing director, or more modernly called the CEO. And the CEO's job, or the managing director's job, is to run the business. So the managing director is an important man, but possibly not as important as the chairman, the non-executive director, because it's the chairman who has the job of appointing the managing director. If you don't have non-execs, and most companies should as a role of corporate governance, then it's the directors who would appoint the MD. Okay, so key points about directors that we need to note here. The minimum age to be a director is 16, and so long as the articles don't exclude you from being a director, or you're not disqualified under the Company Directors Disqualification Act for previous mispractice as a director, then you could be appointed. Every company must have one, PLC must have two, at least, but you can have as many as you like. Even if you haven't been formally appointed, as in maybe a de facto director, your acts are still valid. You will still bind the company. And if you change your directors, if one resigns or you appoint a new one, you must tell the company registrar within 14 days, and therefore that's a piece of public information that anyone can check. Now, if you want to remove a director, how do you do it? Well, there's ways a director could be removed. For instance, if he's dead. He wouldn't want to be a director if he's dead, and you wouldn't want him. If the company's wound up, there's no company for him to be a director of. If he's disqualified under the CDDA, if he resigns, he just decides he doesn't want to do it anymore. Alternatively, he may wait till the expiry of his term. Most directors are appointed for a sort of rolling 3-year period, and a director may just wait till that period comes to an end and then decide he doesn't want to stand any longer. If he's bankrupt, he will be automatically removed, or if he becomes of unsound mind, so he's mentally unable to carry on as a director, he will also be removed. Now, the one I skipped there, probably the most interesting one, removal. A key shareholder right is the power that a shareholder has to remove a director from his directorship. How do they do that? Well, you would think this is a very important decision and therefore would need a special resolution. But that's wrong. It only takes an ordinary resolution to remove a director, so the majority of the shareholders, greater than 50%, must vote for him to be removed. Now, the funny thing about removal of a director is that it's an ordinary resolution on what we call special notice. And special notice means that the company must give the director 28 days' notice of the proposed resolution. And therefore, that gives the director time to decide what he wants to do. And he can make written representations, which can have to be sent out to all the shareholders. Or he can turn up at the meeting and address the meeting and explain why he thinks he should not be removed. You cannot remove a director by written resolution, which won't mean a lot to you yet, but when you come back to revise, hopefully that will be very clear. So just write that for now and bear with me. Now, a directorship is an office, but most directors will also have an employment contract with the company. So although you're allowed to remove him as a matter of company law, you do still have to think about employment law. So you might well have a right to sue the company for breach of contract, wrongful dismissal. And finally, about removal of a director, I just wanted to stress a couple of points here. In the previous lecture, we talked about entrenchment, and we have something similar here because a director might want to protect his position as a director of the company, particularly in an owner-managed type business. So we have a scenario in a case called Bushell v. Faith, where there were 3 directors, 1 brother and 2 sisters. So brother, sister 1 and sister 2. And they each had 1 vote. But each one was slightly worried that the other 2 would gang up on them and remove them as a director. So when they drew up the articles for their company, they agreed that if any one of them was under the threat of a resolution to remove them as director, they would get 3 times the normal votes. So let's imagine the sisters, eventually in this case, decided to remove the brother. Sisters do that sort of thing. So the brother automatically had 3 votes. The sisters still only had 1. So when the vote was cast as to whether the brother should be removed, the sisters could never win. They could not get rid of their brother. And that case actually went to the House of Lords because the sisters argued that such a provision in the articles couldn't be correct and couldn't be valid. But the court said, no, that's absolutely fair. If you've written that into the articles, it is an effective way of protecting one of the directors from being removed from the board of directors. Another way you could achieve a similar thing is to have a provision that each class of shares must be present at a general meeting in order for that meeting to be quorate. Now, a meeting is quorate if it has a quorum, and that means the right number of people present for that meeting to go ahead. So, in order to make this work, each director would have a different class of shares, and there would be a rule that somebody from each class of shares had to be present in order for a meeting to go ahead. That way, if a director knew that he was under threat, he just had to stay away from the meeting, and the required quorum to pass the resolution could never be established. So that's another way of achieving the same thing. Have a look at interactive question number 14. I think that's actually 13 in your notes, and see how you get on. Okay, so those of you who read this will recognise that this is very similar to the Bushell v Faith case that I just described. A company has 3 members who are also directors. Each one has 100 shares. Normally, the shares carry 1 vote each, and the articles say that on a resolution for a director's removal, the director to be removed should have 3 votes per share. On a resolution for the removal of Jeremy, a director, he casts 300 votes against the resolution. The other members cast 200 votes. Has Jeremy validly defeated the resolution? Well, yes, because that is exactly what happened in Bushell v Faith. Okay, so directors are going to run the company. How are they going to do it? Well, because a company is a sort of an artificial entity, if you like, then the people who run the company can only do so if they are given the powers to do that. Now, the Companies Act basically gives the directors pretty much the powers to manage the business of the company. And the Articles of Association can tweak that power. They can give the company more powers or less powers. But a key point is that the directors have to abide by the powers that they're given, either in statute or in the articles in the company's constitution. Now, normally, the directors act as a board, and they act as a sort of collective body. So they hold board meetings and they make their decisions at board meetings. Now, we'll see later, there's quite a lot of rules about shareholder meetings, how they're held and who can attend. But for a board meeting, that can be pretty informal. There's no minimum period of notice. A meeting can be held whenever the directors wish to hold the meeting. And so long as none of the directors actually objects, for instance, I can't make the meeting now, you can't hold it at 5 minutes' notice, then that meeting will be valid. It doesn't even matter that the directors aren't physically present. We could hold this meeting via telephone or Skype or email, whatever. There are, however, a number of restrictions on how the directors exercise their power. The first one is that directors have to exercise their power for the purposes for which they're conferred. So if our directors have the power to issue share capital in order to raise working capital for the company, they can't use that power, for instance, to fight a takeover bid unless they're given further authority. Statute also gives the directors certain powers, but it says the circumstances in which they can operate it. So, for instance, if the directors wish to reduce the share capital of a company, they'd need a special resolution. 75% of the shareholders in a general meeting must give their consent. The articles may place a limit on the directors' powers. For instance, they may say place a limit on the amount directors are able to borrow, or they may require the directors to follow a certain procedure before they enter into debt. And then finally, the ultimate control is the shareholders. They have power to control the directors' powers, either because they could change the company's articles by special resolution, taking that power away, if you like, from the board of directors and giving it to the shareholders in a general meeting. Or the ultimate sanction, as we've already seen, is the shareholders' power to remove a director from office. Remember, that's greater than 50% of the votes and special notice, 28 days notice. Now, while we're on the subject of directors, it's worth revising directors' authority. Now, these are the same 3 headings we had when we looked at agency in Chapter 3. A director is an agent of the company. He acts to bind the company in law. So what do we have here? Well, express actual authority. This is where the director has the express authority. Maybe the shareholders have authorised him in general meeting. Maybe he's been authorised by the board of directors to go out and negotiate a contract to buy a new IT system for the company. We also have implied powers. Now, the implied actual authority of a director depends slightly on the role he has. For instance, a managing director has a very wide power to bind the company. His job might be to enter into contracts for the business, to negotiate sales, to purchase raw materials for the business. His implied actual authority would assume that the managing director has power to do all that. Similarly, other executive directors, a sales director, would have the power to conclude any contract to do with sales. The authority of a company secretary, as we've already said, is pretty limited because a company secretary can only really enter into contracts in connection with his duty as a company secretary. And we saw that in the previous chapter. So that's actual authority. We then have ostensible authority. Remember, this is the sort of estoppel principle. And the key case we saw on that was the Freeman and Lockyer case, which we looked at back in chapter 3, where the other board members allowed one director to act as if he was a managing director. And in that situation, all the commercial contracts entered into by that director were held to be binding on the company. Now, the Companies Act has taken directors' authority a step further, because this whole authority thing, agency point, was a bit of a problem for third parties. If you wanted to enter into a contract with a company, you needed to know whether you could actually treat that contract as binding on the company. So the law has said, well, as far as any third party is concerned, so long as he's acting in good faith, he can assume that the director in question had the authority to enter into the contract. So from now on, if you are dealing with a director, then you're pretty safe in assuming that your contract with the company is binding, that that director had the authority to enter into the contract. Even if that director didn't actually have authority, he will still have a problem, because if the director has breached his express authority, he may well be liable to the company, acting via its shareholders, to make good any loss the company suffers. But as far as the third party is concerned, that contract will be fully binding against the company. Now, it mentions there a test of good faith. We're not really sure how that test will be applied in practice. There's not a lot of case law in it. But it does appear that it's not bad faith if the third party pushes ahead with a contract, even though he knows that the director didn't have authority. So you're looking for something pretty significant. There's also another caveat to this provision in section 40, which says that if the person, the third party in question, is actually a director of the company, or a person connected with him, perhaps his wife or his business partner, something like that, then they can't really rely on this provision. In that case, there's a separate rule that says, well, okay, the contract is binding, but it's voidable by the company. So voidable, remember, means that the company could set that contract aside. And if necessary, that third party, that director or the person connected with him, can be forced to account for any profit to the company or to indemnify the company if it's suffered loss. And that kind of seems fair, doesn't it? Because a third party dealing with the company might not know what the actual authority of a director is. But if that person is also a director or someone closely related to him, they really ought to know what is going on in the company and whether that director really has authority. So it seems unreasonable to extend the full protection of section 40 to a fellow director. Okay, so that's a sort of summary of some key points. What we're going to do in the next lecture is look at directors' duties, and in a little bit more detail. Again, quite an important topic for the examiner.